Addo Boahen. Kwabena Addo Boahen man de why no IT man intina draina e dani trima opese or the ball mine chrono no. Or yes smart guy. Former National Signal Bureau. Abusia ene okokopie mu ewo court na dey intina yese ono ye IT expert intina draina or the dani trim court no kra ye opese obi ti court no eno na ya project e de ato ye screen no enchen e de amamono. Court shoots down Addo Boahen's attempt to disguise his private company's receipt as that of National Signal Bureau. Abusia Kwabena Addo Boahen say opese oye forgel receipt document no or the kokoma court no. I say court shoots down Addo Boahen's attempt to disguise his private company's receipt as that of National Signal Bureau. Say why fake receipt bia opese say ne company no receipt no or turn into a National Signal Bureau for omu receipt na say audit charge no ho ewo eye courtroom. Now we and all the receipt ne buy na judge ne to was massa ye no ye IT expert chen wo na wudina ono onye smart guy o fake document na o company no receipt na o pese o change in the name of National Signal Bureau receipt no papa ya chill she ni wa ebetumi etwitwa de agyew enti hu de ewo ye enti Kwabena Addo Boahen ne fake ne illegal receipt bi anka or pese or de be bri court na ni so no abusuya judges no action abusuya eno ne breaking news e wo ho a ye de ebrem na anti-corruption cases bin so ekoso mo me yanko na yankonkuti ensema ekoso unsubscribe ya subscribe na hit on the notification bells and any updates be ever dropping also onsa ebetumi aka gossip politics TV so madam say
politically connected or politically exposed or within the party of the serving attorney general. That was the thinking. Yeah. There was some conversation that preceded the establishment of the office. And as to whether the law that establishes the office is what has created this problem as we are dealing with now. It's another matter that we want to get into. But I recall that the political parties platform, which Professor Jampo was part of, the leading members at the time, were the ones who were doing this engagement for the office, for a separate office to be set up to deal with certain cases that the Attorney General, because of the political nature of it, cannot deal with. Was it the outcome that you were asking for? Prof, quickly.
Well, thank you very much. Way back in 2008, I recall the Ghana Political Parties program that then had representation of all the political parties that had seats in Parliament had commissioned a study led by one Professor Reginald Austin and Professor Kofi Kumado to audit the gaps in Ghana's democracy. That study culminated in a certain paper that was also referred to another committee comprising people like Professor Kwame Ahoy, Professor Yauchumesi, Dr. Ahaji. In their further study of trying to audit the gaps in Ghana's democracy, generated a paper called Democracy Consolidation Strategy Paper that generally argued that even though Ghana's 1992 constitution had served us well, nevertheless it contained provisions that were hindering the maturation of our democratization process. So they identified the gaps and made recommendations for constitutional review with a view to addressing the gaps. Now, one of the challenges that they identified in their audit of Ghana's democracy was about the fact that we have an Attorney General who is also the Minister of Justice. And they had argued that in a fight against corruption, it is oftentimes difficult for a certain Attorney General to be dealing or prosecuting his own other colleagues who are serving within the same government with him. And so the recommendation that was made then was the need for us to separate the Attorney General from the Ministry of Justice and then create an office that they were referring to as independent public prosecutor. An independent public prosecutor. In fact, if you read the Democracy Consolidation Strategy document, whose recommendations were bought into by Professor Mills and culminated in the Constitution Review, that was the recommendation that was made. You need to separate the Attorney General's office from the Ministry of Justice and then create an independent public prosecutor, not special prosecutor, independent public prosecutor. People had their own fears about it, that if you don't take care, this guy would also be prosecuting all your appointees and all that. But then that was the recommendation. Soon after President Akufo-Addo became president, I think he was also privy to this conversation. But he was aware that in trying to separate the the Attorney General's office from the Ministry of Justice, and in trying to touch the prosecutorial powers of the Attorney General, it was going to require a certain constitutional amendment, and that particular Article 88 of the Constitution is actually an entrenched clause. So I think the easiest way out that he resorted to was to create the special prosecutor. And when this was done, some of us had issues with it. I mean, right from the word go, because we were juxtaposing the special prosecutor that had been created, its functions, with the provision in Article 88 that vests the prosecutorial powers of the state in the Attorney General. And so right from the word go, we knew that there were going to be problems. But, you know, Ghanaians were also tired of corruption. And so once you had a special prosecutor set up, and particularly what excited people in not delving or thinking deep into the problems that could arise was the appointment of the person in the persona of citizen vigilante. So people applauded it that, well, I mean, with this man, no nonsense person is going to do the job. So that sort of blindfolded people into looking at the potential conflict that could emerge. And so Amidou left, Kisi came, and it's been on and on. I mean, I quite remember one day I was arguing that the special prosecutor was going to have problems because he was going to be working in the shadows of Attorney General. And somebody drew my attention to the fact that, look, their act says that even though they are going to be drawing their prosecutorial powers from the Attorney General, they nevertheless are expected to operate, you know, in an independent manner. And I kept asking myself that, how do you draw your prosecutorial powers from AG and still be independent of the AG? And today, somebody has gone to court and he's gotten a judge to give a certain judgment.
Also, when the AG could even internally prosecute, even through your prosecution.
That is it. So somebody has gone to court and gotten a certain judgment, and I think now we are all awakened to the realities the realities of the conflict that right from the word go was created by the passage or by the setting up of the office of the special prosecutor. Look, this matter, if you don't handle it well, if you don't talk about it well, then you are seen as somebody who is now developing a cold feet against, in the fight against corruption. But the point is that reality is setting in. We are all tired of corruption. We want corruption to be confronted head on. But at the same time, we must also not blindfold or be oblivious of the legal contradictions and the realities that confront us. So an individual has gone to court, and this is a ruling.
Okay.
Are we now going to look at the courts and tell them that they are wrong without seeking a review? So I think that, look, what has happened has generated a lot of public discourse on this. anti-corruption crusaders, some of them are looking at things dispassionately. I can see some of them are also being emotional. That no, I mean, why are you touching the special prosecutor? But I'm saying that we cannot confront corruption without looking critically about some of these legal contradictions that exist. Because if we blindfold ourselves to the realities, then we may be going a certain tangent. Somebody gets to the court, and then he throws sand into our gari, and then we are all disappointed. So I think that the consequences. The time has now come for us to all sit and look at things dispassionately.
Okay.
Whether we want the office of the special prosecutor to operate in the environment of this legal contradiction, it's up to us to decide. The office of special prosecutor, in my view, has got the option of either going to the AG and getting whatever authorization so that he can continue his case. He also has the option to go to court to seek a review. But ultimately, it is important for us to appreciate the fact that you cannot allow this kind of contradiction to exist, particularly when we have not done anything about the prosecutor, about amending the prosecutorial powers, of the AG in a manner that gives it high set off to the special court. If we've not done that, then anybody can go to court, and once they get this kind of judgment, then you can't blame anybody. So the point is that we must be open about this, be dispassionate about it, and see how we can navigate, this particular situation in a manner that will not make us look like we don't want to fight corruption, in a manner that will not also make us look like we are seeing problems in terms of conflict of laws, and we want to pretend that because we want to focus on a particular tangent, that conflict should
on
not...
the matter of the authorization, Dr. Adam stated in that interview that according to him, said the OSP is not interested in coming to him for the authorization because the special prosecutor says that office is independent. That's according to Shrem side.
Well, but I don't know what the lawyers here say, but I think that to the extent that nothing, if nothing bars the special prosecutor from going to the Attorney General to seek clearance to be able to prosecute, then I don't see why we shouldn't be able to do that. It appears also that reading in between the lines, I think there's been some turf wars, but whatever is happening, the point must be made that the prosecutorial powers that are given to the Attorney General are quite entrenched, and you cannot just push it aside and pretend it doesn't.
That's why I started this conversation with the details of those two provisions, Article 88 and Section 4.2 of the OSP Act. You want to say something quickly?
So I respectfully, Prof, your statement that reality is now settling in, I think is far from the truth. I'd like to take you back to the Hansard of November 1st, 2017. And I want to point out to you that these issues were thoroughly debated. Ghanaians are not now waking up and finding that all of a sudden the wording of the Constitution is this and LI 2374 and we are hitting our heads. Not at all. So let me read a bit of the Hansard for you. And I would like to appeal to Ghanaians to spend time, go to history so that we don't seem to be reinventing the wheel all the time. Now, the debate regarding the authorization of the OSP as it had folded was as such. Mr. Banda, who was a proposer of an amendment to the Article 88 that we are looking at, he moved an amendment to insert the phrase that the OSP shall be authorized by the Attorney General. His rationale, his goal was to strictly tether the newly created Office of the Special Prosecutor to Article 88 of the 1992 Constitution, which vests all prosecutorial powers in the Republic in the Attorney General. Then Dr. Dominic Aine, the pragmatist, what was his position? He supported the concept of authorization, but vigorously demanded that the method of authorization should be explicitly defined and structured. His rationale. He argued that since Parliament was using a statute to compel the AG to delegate authority to the OSP, there had to be a clear mode of delegation. He explicitly suggested using a constitutional instrument or a legislative instrument to spell out the jurisdiction, ensuring that the OSP will not be left in an administrative limbo. Then Prof. Mike Okwe, the speaker at the time, an independent purist, his position, he pushed back. He said that the entire concept of the OSP needs an explicit warrant or authorization from the AG to do his job. His rationale. He believed that an act of parliament creating the office was authority enough. He delivered a prophetic warning that demanding ongoing or secondary authorization from the AG would open an unnecessary Pandora's box of co-ranto legal challenges demanding to know by what authority the OSP acts, whereby paralyzing the anti-corruption fight. Which position won? There was a structural compromise won. Parliament could not ignore Mr. Banda, and so the legal requirement for the AG's authorization was kept in the Act. However, to prevent the exact paralysis the Speaker warned about, Parliament adopted Dr. Ine's solution. They created a framework for structural delegation rather than requiring case-by-case permission slips.
Is that from the Hansard? You are interspersing with comments. Read the Hansard, they know.
Let me finish my point. Let me finish my point.
Get serious.
So the OSP eventually, and so I'm trying to say that to suggest that this is new.
Okay.
Read the Hansard.
But I think it's instructive that you reference that a member of parliament also raised the possibility of what we're even seeing now.
Absolutely.
With the co-aranto application that has resulted
in saying something different.
Yes, I'm saying we are all forgetting the history. Let's go back to the Hansard and see that this issue was dealt with. It is not that we suddenly woke up and then we are surprised. No. The issue came up, it was debated, and they agreed on a certain compromise. That compromise is what is reflected in LI 2374. So even if we are having this discussion now,
But the LI is
but just for the at least specifically, this point was made. Hold on. I want to hear one person. Listen.
no, the constitutional provision.
Hold on. This particular LI was referenced in the course of the engagement, and the compromise, so-called, that was captured in
Absolutely.
there. Because of Article 11 and the sources of law and the hierarchy of the laws, the question as to whether the LI supersedes the constitutional provision is one that also then. So then, how do you reconcile
No,
this
but
position?
the Constitution says delegated by law. Do we have a law? We do. Act 959. Does that law empower the OSP to do what it's doing? Yes. Has it been repealed? No. Does it talk about investigation and prosecution? Yes. So unless we are saying that the Act 959 does not satisfy what is required by Article 88.
Okay, I was near winning and some so our political highway. So Kwabena do Boahen and CCR on the home as answer a treno on any lawyers no our quarter and ye as some get to a crabamasi, some of Japan, Cocotiza and some way at my aha, a gossip politics TV. So, Madam.